Welcome to I May Be Wrong.
I don't know what this world is coming to,
but I don't think so. We're broadcasting from the greater Nashville area, the home of country music, beyond the borders of political correctness and identity politics. Facts and faith are our demarcations. Truth lights our path.
Here's the Barry White of Podcast Radio,
the Venerable Alfonso Ashworth.
Well, welcome to another exciting episode of I May Be Wrong, but I don't think so. Of course, I'm Alfonso Ashworth. We got a great program lined up for you on this segment. Of course, I have someone waiting in the queue that's gonna settle some of these issues when it comes to your right to keep and bear arms. Trust me, there are many out there who are attempting to take that right away. If they have to do it one letter or one syllable or one segment at a time, that's what they're going to do. You can just look, they're not trying to hide it anymore. There's no more questions about, well, are they or aren't they trying to do this? Maybe they just want to get certain firearms away. Maybe we should just consider giving up some of those firearms. Maybe. I'm going to tell you, if you're willing to do that, you should ask yourself, where does it stop? And, of course, my guest is in the queue, John Harris. Now, John has been doing this a while. So he's no Johnny come lately, so to speak. John has been an attorney in Nashville since 1986. That's the year I opened my business, by the way. He's associated with the law firm of Shulman, Leroy Bennett, PC. His practice represents businesses, nonprofit entities, individuals, general civil matters, corporate governance, estate, trust, transactional, and litigation matters. Mr. Harris has handled many cases involving clients before the Bureau of Alcohol, Tobacco, Firearms, Explosives, including clients that have or are seeking licenses, or he's also undergoing license revocation proceedings. That means that somebody is trying to take that right away. Now, before I get started, I'm going to play you just a short clip in just a minute, and hopefully this will bring you to attention that what they're trying to do is real. You know, and of course, if you would like to chat, you can chat with me in the chat room. You can ask questions. But listen quickly before we finish and get John on. I just want you to hear this.
I do want to come to Congressman O'Rourke because I know this is personal to you. El Paso is your hometown. Some on this stage have suggested a voluntary buyback for guns in this country. You've gone further. You said, quote, Americans who own AR-15s and AK-47s will have to sell them to the government, all of them. You know the critics call this confiscation. Are you proposing taking away their guns, and how would this work?
I am, if it's a weapon that was designed to kill people on a battlefield. If the high-impact, high-velocity round, when it hits your body, shreds everything inside of your body because it was designed to do that so that you would bleed to death on a battlefield and not be able to get up and kill one of our soldiers. When we see that being used against children, and in Odessa, I met the mother of a 15-year-old girl who was shot by an AR-15, and that mother watched her bleed to death over the course of an hour because so many other people were shot by that AR-15 in Odessa and Midland. There weren't enough ambulances to get to them in time. Hell yes, we're going to take your AR-15, your AK-47. We're not going to allow it to be used against our fellow Americans anymore.
Well, there you have it. I mean, there's no question about what they're intending to do, what their motives are, how they're planning to do this. The question remains is, what are you going to do about it? You know, of course, the guest that's in the queue, John Harris, has been doing this, and Mr. Harris teaches legal education courses in issues of firearms. He's using deadly force under Tennessee law for attorneys. Mr. Harris has served as the executive director of the Tennessee Firearms Association since 1995. He is an author of several publications, including the book Carrying a Handgun for Self-Defense in Tennessee. Mr. Harris is licensed to practice in Tennessee, the Sixth Circuit, and before the U.S. Supreme Court. He received his BA degree from Vanderbilt University, his JD degree from Vanderbilt School of Law in 1986. Welcome to the show, Mr. John Harris.
Good morning.
Good morning, sir. Great to have you on. I know that you're a very busy person. We have not met in person, but we have a lot of people that we are connected to that highly recommended that I get you on the show. So I made that effort through a dear friend of ours that we have, Sherry Orange. And, of course,
yes,
Sherry
correct.
speaks very highly of you. Let's get right to it because we only have a few minutes on this show. So I want to give you all the stage, every opportunity. Tell my audience what it is that you do in your line of work that is so important at this time.
Well, in relevance to the discussion this morning, I serve and have served for the last 25 years now as the executive director for the Tennessee Firearms Association. And I also serve as the treasurer for an affiliated state PAC. In those two roles, we spend a lot of time and effort working on not just legislative issues, but increasingly court-related matters that impact Second Amendment issues for not just Tennesseans, but particularly in the litigation side of our activities for citizens across the country. And those could spectrum from things like handgun permits, constitutional carry, but we also get into range protection, no net loss of hunting lands, just a wide variety, almost anything that touches the gun owner.
Well, and also in matters that are in that gray area, I'm going to give you a scenario. You tell me, matter of fact, it's not even a scenario. It's something that just recently happened. You tell me what would my rights be as a legal gun owner. Say, for instance, I come home, I've got a few friends, we've been out, I get to my home, someone's broken into my home, and they confront me in my yard, and they're armed, and they have on masks, and there's no gray area about what they're doing, and they actually point their firearm and fire that firearm at me. Me, as a legal gun owner, what are my rights?
Yeah, Tennessee has a statute, and it's 39-11-611. That's the self-defense statute. And essentially what that statute says, whether you're a gun owner or not, is that if you're presented with an imminent fear of death or serious bodily injury, that you have the right to use deadly force or such amount of force as is reasonably necessary to stop or avoid or end the threat to your life at that point in time. So, in your example, if someone is confronted and they're innocent, they didn't provoke the fight, they weren't the initial aggressor, the person under Tennessee law has the option, so to speak, to resort to deadly force to protect their own life. They have the right under Tennessee law to resort to deadly force to protect, let's say you had a companion with you.
Correct.
To protect their life. And then once you get into with the in the yard, in the home issue, is Tennessee has set up some additional provisions under that same statute that say, if you're in certain protected locations, your home, your motor vehicle, an apartment, a hotel room, maybe a tent, a camper, an RV, out in your own yard even, in your place of business, that the law presumes that someone who has feloniously entered that protected area presents an imminent fear of death or serious bodily harm. But that's just a presumption, so it can be rebutted in a trial court, but the presumption is there.
Okay, and so under Tennessee law, if my scenario or the situation I gave you, I would be well within my right to defend myself and my friends. Let's make that a little more gray, I guess I could say. If it was a neighbor and I saw this happening, and I came to my neighbor's defense, where would I stand if I was the one who stopped the assailant with my firearm?
Right. The Tennessee statutes address that, and they say basically that if you come upon a situation like your neighbor, and your neighbor would have been justified in using deadly force on their own to stop or avoid an imminent threat of death or serious bodily harm, that you can assist them in doing so. But the law is pretty clear that you have to know that the neighbor would have been justified. So, for example, if your neighbor was being arrested by an undercover cop that just looked pretty rough,
right,
and you didn't know all the facts and you shot the undercover cop, you may have a problem.
Right. So that's where we as gun owners, we have to not only just know the law, we have to be very careful when we're exercising that right as to not only interfere with law enforcement, but also maybe be charged ourselves with the crime. And, you know, I don't know if you heard a little bit of the clip, and you've probably heard the clip from Beto O'Rourke when he was talking concerning what he would do as president. You know, some people just laugh at it. They laugh it off. They say, well, it's never going to happen. They're not going to take your firearms. They're not going to come and get them. But when somebody blatantly says, look, this is my intentions, this is what I want to do, and he sort of left that room as to what he would do versus an AK-47 or AR-15 or what he calls an assault weapon that should be on the battlefield. Well, I would argue my front yard had became a battlefield in essence. I'm fighting for my life. I'm fighting for my friend's life. And it just happens it's happening in my front yard. What do you think about what Mr. O'Rourke said concerning taking those firearms?
Well, you know, first, it is concerning because he is speaking to a group that is receptive to that message. And that is concerning because those people vote or have the ability to vote. But Beto O'Rourke and that message of weapons of war shows an absolute void for understanding of why the Second Amendment even exists. You know, our founding fathers didn't just get back from a safari hunting big game.
Correct.
You know, they had just fought the largest military force in the world at that time on our home front and defeated them. And they were specific that they were intending to protect to the civilian bodies, you know, which, if called upon, forms the militias, to have access and the right to own and use and train with firearms suitable for military purposes. And that's beyond really any dispute at all, even in the case law, at least up until about the 1940s. And I'll give you an example. There are two old Tennessee Supreme Court decisions, one from the 1830s and the other from the 1870s, both which address the scope of the constitutional right or the constitutional guarantee of the right to keep and bear arms under the state constitution. And both of those cases, one's called Amet and the other's called Andrews, specifically reference the fact that the purpose of the constitutional protection is like the First Amendment, is to prohibit the government from infringing the political right of the citizens to have access not only to the soapbox, but to the armory to possess firearms suitable for overthrow of a tyrant, as well as general defense of the communities. And you come forward with that concept, and even in the late 1930s, there's a brief that the U.S. Department of Justice filed in a Supreme Court case called Miller, where the argument was, is a sawed-off shotgun a weapon that is protected by the Second Amendment to civilian ownership so that it could not be regulated, in that particular instance, taxed by the government? And the Department of Justice's argument was, and this is in their brief to the Supreme Court, that it's beyond dispute that the Second Amendment protects weapons that are of the nature and type used by the infantrymen, the military. The Department of Justice's argument was that the sawed-off shotgun isn't used by the military. And the Supreme Court generally agreed with that analysis and said, we need to send this case back to the trial court to develop additional facts on whether or not the military, U.S. military in the 1930s, uses, for any reason at all, sawed-off shotguns. And the implication being, if the military uses them, the Second Amendment protects them, and the government can't regulate them.
So, in essence, whatever that we allow our military to use to defend us, your argument, and I think the argument that should be made, is I should be able to do the same within my ability to purchase, get a license, use in a proper way to defend myself, not just out here, shooting a cannon off just to annoy my neighbor. But break the Second Amendment down, because the argument I get all the time from these people who say, well, why do you need a gun that shoots so many rounds? And why the argument that you hear. Break it down in a way that maybe I know I understand it, but some people just, they don't understand how to dissect a sentence. I don't know.
And
that's the problem. Break it down for them.
We've got to look at the fact that this sentence was written in the late 1700s.
Correct.
At a time following a major battle fought by civilian subjects against a tyrant king in the name of liberty and freedom. And when this issue got to the U.S. Supreme Court in the Heller decision in 2008, Scalia spent well in excess of 50 pages breaking down this sentence with excruciating analysis. And essentially, here's what he says. If you look at what was going on in the use of phrases in the 1700s when this was written, the militia was a specific term that they understood. And the concept of the militia back then was sort of the Lexington and Concord concept of it's all the adults out there, whether they think they're part of the military defense services or not. Every adult citizen is part of the militia. And in fact, in Tennessee, we have statutes that say that adults between certain ages, and I think it's 18 and 45, specifically are subject to the militia call of the governor. And if the governor makes the call, now, it's not likely it's going to happen these days, but we have statutes that say if the governor makes the call, they're to show up outfitted and ready for whatever purposes they may be called into service. And if they fail to do so, they can be criminally prosecuted.
Is that part of when a male turns a certain age, we have to register?
No, that's
entirely separate. Okay, got you. Go ahead, finish.
Yeah, that's the national draft, and see, if you remember, even up through World War I, many of the armed forces were the First Tennessee. They were. It was almost World War II before we started talking about military forces and divisions without referencing a state being connected to them. But before that, you almost always referred to divisions and battalions and whatnot with some kind of geographical reference of which state those people came out of. But the federal draft is an entirely separate creature because this concept of the militia goes back centuries.
Okay.
And it's the citizenry with essentially a fundamental civic duty. And that's why they talk about the necessity that you have a well-regulated militia. And well-regulated doesn't mean that they're, under the authority and restricted by the government. Well regulated simply meant, according to Scalia in the literature, that these were citizens like Lexington and Concord that owned arms, had ammunition, and they went out frequently enough and practiced with them that they knew what they were doing.
Well, and that answers one of my questions as well, as far as my duty and responsibility as a Tennessean, as a citizen of the United States, and as a person who is a legal firearms owner, that if my state asks me, or, please join us in defending this state, I would not hesitate to do that, because I feel like that's my duty. And you just told us legally what that looks like. As far as the firearms are concerned, the AR-15, the AK-47, all these firearms out there that have become the center point for the argument to do red flag laws. Explain to my listeners, what does the red flag law, what does it do, and how would you legally explain it?
Well, the red flag law is a euphemism to try to make it more palatable for what is more commonly and accurately referred to as an extreme risk protection order. And here's what's happening. In about 1968, the federal government started passing laws, the Gun Control Act, that tried to define that certain people, convicted felons, for example, people that were dishonorably discharged, there's a series of classifications, that these people had lost enough of their civil rights that they were classified as prohibited in terms of possessing firearms. And so we've had this, 50-something year history now of classifying, categorizing activities, crimes, conditions, which are severe enough that constitutionally, under the scope of due process, the courts have said that that's a severe enough thing, like a felony conviction, that we're going to allow you to infringe or take away a right that is fundamental and is protected from the constitutional viewpoint from government infringement. So what these red flag laws do, these extreme risk protection orders, is you have some, almost all in government or on the far left, who are saying, with respect to events like, Parkland, Las Vegas, these mass public shootings, if we just had more laws, we could stop these things. If we just had the capacity to come in and identify someone as a citizen who's on the bell curve, outside the range of normal because they've said something or they've done something or they've acted in a peculiar way, they may have not committed any crime at all. But what this red flag movement is all about is they want to have the ability to come in and identify people that they say are such an enormous risk based upon prior activities that they might do something in the future, and we want to take away certain constitutionally protected rights. And there's huge due process problems with that. It's sort of like the no-fly list. These people aren't telling us who gets to decide if you've met the red flag standard or not, how you challenge it, how you get off of it, what happens if it becomes weaponized in divorces, for example, and it becomes the bigger problem in the room. And there's no data that really proves that these things are effective to stop the risk that someone has an emotional disturbance or a terrorist tendency is going to go out and commit a crime. And what they don't do is they don't take that person, particularly the ones with mental health issues, off the street and get them treatment. They try to separate the person from a specific weapon or class of weapons. And it really doesn't even stop them effectively from going and getting more. because they could always, even if they don't have a gun, they could always go get a car, fertilizer, knives. You know, look at Britain now with the number of knife attacks, and they don't have access to guns hardly at all.
So, and you know, you explained it perfectly. And of course, I understand what it means. It means we're headed down a slippery slope to where people's constitutional rights are going to be taken away without due process. And that's unconstitutional. And of course, we're opening that Pandora's box to where all of a sudden someone doesn't like me, or someone thinks I've said something on the internet that's threatening, and I'm then challenged in court somewhere and have no idea where that may lead. Now, of course, you got about a minute or two. Tell my audience, one, what of course, you've been working in this area. Give them some more specifics about, you know, if they need your service, or how do they get in touch with you if they need to discuss these matters further?
Sure. If they would like to get more information about the Tennessee Firearms Association, their website is TennesseeFirearms.com. If they would like to support the Political Action Committee, that is TFALAC.org. That's TFALAC.org. And it's actually got a big auction and a barbecue luncheon coming up on October the 5th.
Yes.
And then if they have a need for an attorney, I'm a practicing attorney in Nashville, and I represent gun dealers and explosives companies and individuals with firearms issues as part of my practice areas. Okay.
And of course, the barbecue that you just mentioned, I've been invited, and if I hope to be there, and if you're there, tell the audience if they would like to be a part of that. Where is that going to be?
That's going to be on October the 5th, which is a Saturday, at Smiley Hollow, which is up in Goodlettsville. It's a midday event, so if they're 2 hours away from Nashville or whatever, they can come in. The doors open at 9. We eat about 11. We'll have a live auction and a silent auction following the lunch meal. We typically sell somewhere between 20 and 30 firearms at the live auction.
Yes.
And then we have a wide variety of other things for auction, including Pigeon Forge vacations, Florida vacations, all kinds of stuff.
Wait, and, I can't wait.
And all the money goes to the PAC, which is used to support candidates that support the Second Amendment.
Amen. John, brother, thank you so much for coming on the show today. I really appreciate it, and hope to see you at the event, and we can chop it up a little bit more. But thank you for coming on. I may be wrong, but I don't think so.
Well, I appreciate the invitation and look forward to doing it again, and hope to see you on the 5th.
All right. Thank you, sir. Of course, that was John Harris, attorney that specializes in issues concerning the Second Amendment. If you don't think your rights are being under attack, just listen once again. And of course, that was a clip. It's going to be a clip from Mr. Beto O'Rourke, and let's see if we can get him to. That clip's not wanting to play again. But anyway, we played it earlier, and it's basically Beto O'Rourke talking about the issue. Here it is. We got it up.
I do want to come to Congressman O'Rourke because I know this is personal to you. El Paso is your hometown. Some on this stage have suggested a voluntary buyback for guns in this country. You've gone further. You said, quote, Americans who own AR-15s and AK-47s will have to sell them to the government, all of them. You know the critics call this confiscation. Are you proposing taking away their guns, and how would this work?
I am. If it's a weapon that was designed to kill people.
Notice he said a weapon designed to kill people on the battlefield.
The high-impact, high-velocity round, when it hits your body, shreds everything inside of your body because it was designed to do that so that you would bleed to death on a battlefield and not be able to get up and kill one of our soldiers. When we see that being used...
You know, under his conditions, you would probably not be able to own a pellet gun. That's just the facts. Of course, if you would like to know more about the show, you can join us at IMayBeWrongButIDon'tThinkSo.com. Please consider being a donor. And I want to thank you for listening in today with our guest, John Harris. I'm Alfonso Ashworth. God bless you. God bless America. God bless our children. And peace.
You've been listening to Alfonso Ashworth, the Barry White of Podcast Radio. Go forth and share his message. I may be wrong, but I don't think so. Remember, no two people can ever occupy the same place at the same time. You were uniquely and wonderfully made. Born an original. Don't die a copy. God bless. Peace.